So I have hundreds of pages more written, but as far as the book is concerned, this is the last portion. Will be the last video for what I've written towards the book. Um, okay, so Article 3, Section 1 states the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges both of the Supreme Court and inferior courts shall hold their offices during good behavior and shall at stated times receive for their services a compensation which shall not be diminished under the continuance in office. Excuse me. The judicial branch of government is created and established by Article 3 of the Constitution, the beginning of which reads, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Therefore, Supreme Court is explicitly established in the Constitution, being separate from both other branches of government, hence creating a third branch. Congress, however, is responsible for ordaining the other courts inferior to that of the Supreme Court. Contemporarily, we have three levels of federal courts: trial courts, appeals courts, and the Supreme Court, containing approximately 800 federal judges. All of the judges and the justices of the Supreme Court are nominated and confirmed, the former by the President and the latter by the Senate. There is a question of why the Founding Fathers would establish the Supreme Court, believe the establishment of lesser courts to the legislature. The answer lies within the debates of the Constitutional Convention and further. Citizens at the time were worried the federal government was too powerful, and federal judges were almost considered foreign to those of the state's judiciary. Others, however, argued that it was necessary to have a federal judiciary in order to maintain the effectiveness of the new federal government. The compromise lies in the establishment of the Supreme Court, which would ultimately receive the final word in the predicament of state courts intervening with national maintenance. The rest of the federal judiciary would be subject to day-to-day politics and decisions. Article 3, Section 1 also reads, the judges, both of the Supreme and inferior courts, shall hold their offices during good behavior and shall, at stated times, receive for their services a compensation which shall not be diminished during their continuance in office. This provision is designed to make sure that the judges are independent. Therefore, judges are not swayed by petty politics or the bureaucracy at large and do not have to worry as much about objections. The only way for federal judges to be removed from office is by impeachment from the House of Representatives and by conviction in the Senate. Very few people think that federal judges should be elected. This is key to maintaining their independence, of course. However, some have been critical of federal judges' lifetime tenure and have proposed amending this to shorter terms, such as 14 to 18 years, with no possibility of being appointed again. It is important to note that in the federal government, there are other agencies and organizations that employ judge-like officers who make rulings on various instances. Some of these figures are swayed much more by day-to-day politics and have shorter terms in office holdings than do federal judges, yet still make decisions on the settling of disputes daily. It is also important to note that there is typically the option of appealing these bureaucratic decisions upward to a judge with lifetime tenure and less susceptible to the swing of politics. The Constitution deliberately and explicitly designates the federal court system as having the judicial power of the United States. It is, however, less explicit in describing and defining judicial power. The federal courts are ordained to solve issues relating to judicial cases and actual pursuit of justice, though their ordination gets generally more hazy in reference to the legal implications as well as constitutional implications regarding legislation. Some of the Founding Fathers argued that the judicial branch of government was the weakest of the three, but other critical Founding Fathers saw the judicial branch as having the ability to shape the government through their judicial review. A branch of government that gets to decide whether the branches may or may not do, and that gets to overturn policy choices made by elected and accountable branches is not the weakest. Very much so, the judges of the judicial branch are independent. However, this can be viewed as the justices of the Supreme Court lacking accountability and oftentimes deciding major cases that are contrary to the majority opinion. The first section of Article 3 is the backbone of our legal system and creates the Supreme Court and the foundations for the federal court system. There have been many unintended consequences of the Constitution not perceived by the Founding Fathers. They, for example, intended to only have one federal court system, that of the Supreme Court. All other court systems would exist solely in the sphere of the state systems. Of course, there would always have been the ability to seek a Supreme Court hearing, but it would be nearly impossible for the Supreme Court to handle that magnitude of cases. It is not to be misunderstood that state courts do, in fact, handle much more than the federal courts in regard to the country's judicial responsibilities. and it is complicated and technical to decide which cases go to the federal courts rather than being handled by the states. For those who feel their federal constitutional rights are being infringed upon, they are much more likely to be heard in a federal court system. It is not to be underestimated the amount of justice that has been achieved through the inferior courts of the federal court system. It is known that many in the government make decisions that are similar to those handed down by judges. The founding fathers would not have been able to imagine there being thousands of federal employees making important decisions daily. The important instance to take away from such a fact is that many, if not all, of these decisions can be appealed to by an actual judge in the federal court system. It is important to note that this hugely important part of the federal government reflects another one of the many ways in which our Constitution is not just an unshakable foundation, but a flexible institution. Article 3, Section 2, the judicial power shall extend to all cases in law and equity arising under the Constitution, the laws of the United States, and treaties made, or which shall be made under their authority to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof, and for a state, citizens or subjects, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as the law and fact, with such exceptions and under such regulations as the Congress shall make. The trial of all crimes, except in cases of impeachment, shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed, but when not committed within any state, the trial shall be at such place or places as the Congress may by law have directed. The following is in regard to the federal court system, which is separate from that of the states, which have control over their own rules and regulations. Okay, so the first section of Article 3 prescribes the creation of the federal court system. Specifically, a Supreme Court is to be established. Congress was permitted to establish lower court systems, and they did so almost immediately with the creation of district courts as well as circuit courts. The ability of the president to nominate such federal court judges and justices is outlined in Article 2 of the Constitution. The nominations are then confirmed by the Senate, and the appointments are made. Therefore, it can be seen that judges and justices are appointed at the discretion of elected officials, and it is not until after that that their position becomes independent of the sway of politics. It is important to recognize that there is a lack of discernible budget for the federal court system. However, Congress has been reluctant to support such federal courts. Article 3, Section 2 outlines cases or controversies to which the judicial branch's power is extended, some of which include all cases in law and equity, as well as maritime-related judicial processes, and of course, issues between states. The Supreme Court, since its establishment, has structurally interpreted the meanings of the words case and controversy, and the federal court does not give advice to the other branches of government. Also, there is a question on whether a case is justiciable, and what type of injuries constitute proper harms to be addressed by the court system. At different times, the Supreme Court has had original jurisdiction over cases or appellate jurisdiction. There are many arguments and controversies over the extent Congress's jurisdiction over judicial appellation based upon the constitutional text stating the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. One argument believes that judicial authority is exclusively guaranteed to the judicial branch, while the other side believes that there is much room for congressional intervention. The most prominent scholarly interpretation is that the Supreme Court is more protected in regard to original jurisdiction, and there are protections that come from both the 5th and 14th Amendments, which relate to legal protections. Article 3, it is important to note, also provides protections for decisions based on a jury, including the requirement that criminal prosecutions on the federal level be a jury trial, with the court taking place where the crimes were committed. Also, case law and interpretation read Article 3 as protecting values of openness and judicial independence. There has not been much argument about Congress's regulation of the jurisdiction of the federal court system when initial implementation was that of fitting descriptions of particular cases to the eligibility of such federal jurisdiction. For example, most legal review in the federal court system is not constitutional and is statutory oriented, and we should look to these statutes to determine the boundaries of jurisdiction exercised by the federal judiciary. These statutes have to be measured against the rest of Article 3, most importantly, against the categories of cases to which jurisdiction shall extend. Accordingly, there are 5 related ideas to take into consideration. Firstly, if the jurisdiction is exclusive or concurrent in describing the relation of the cases between the federal and state judiciaries. Secondly, the definition and description under which these cases fall. Thirdly, the determination of whether Congress gives such jurisdiction or if the Constitution explicitly implies it. And if any limitations by Congress can be put in place. So, fourthly, obligations are required by parties to the federal court case. And fifthly, the reparations authority of the courts as allowed or disallowed by Congress. It is complicated to discern whether a legal implication is directed under state law rather than federal law, making it difficult to discern whether the implication falls under federal jurisdiction. To further complicate matters, the Supreme Court has held that federal laws can implicate other federal laws and prevent hearings on either one or the other. The third article of the Constitution does not prohibit certain trials in different jurisdictions based on wording describing court cases to be heard in certain jurisdictions, and an even more complex iteration. This is an even more complex iteration. These types of cases involve those falling under affecting ambassadors, other public ministers, and consuls, as well as those under admiralty and maritime jurisdiction, the lines of which are blurred when it comes to which jurisdiction presides. These blurred lines even extend to employees of the federal government. If a postal officer is sued, does that imply that the United States as a whole must come to court? And when is it implied that a state as a whole must come to a hearing? It is also very complicated in regard to the bringing of one's own state to court. The Supreme Court has gone so far as to deny the constitutionality of receiving such a case in federal court. In regard to the litigation of interstate court cases, there is a large swath of bias and partiality, and in many cases, federal judges must generally apply state law. To summarize, Article 3 has been enormously generative. The boundaries of the Supreme Court are particularly determined by tradition and intellectual concept, such as has been the epitome of intense interest and debate. Article 3, Section 3, treason against the United States shall consist only in levying war against them or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or on confession in open court. The Congress shall have power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Treaty is the only crime defined within the Constitution and applies to Americans who have gone against the allegiance they are presumed to owe to the United States. However, there are many limitations on pursuing a treason trial instilled within the Constitution to prevent false accusations and prosecutions. The Constitution details what treason is in regard to conduct to the United States, but more importantly, it limits it to 2 scenarios: conducting war against the United States and giving aid and comfort to its enemies. Only one person in the United States' recent history has been indicted for treason, but the Supreme Court has been given the opportunity to further define it with each case throughout history. It has been decided that merely conspiring to commit war against the United States is not grounds for treason, and levying war against the United States has been restricted to narrow interpretations. The other scenario for a treason trial is also subject to narrow interpretation. The Supreme Court argued that having sympathy for the enemy and being disloyal to the United States does not mean the giving of aid had taken place, and therefore no treason will have occurred. As long as there is no adherence to the enemy and giving of aid and comfort, treason has not taken place. Treason cases can only be proven in certain circumstances. There must be open confession in court or a testimony of 2 witnesses to the same overt act. Therefore, the witnesses cannot simply testify to a defendant's mindset and must witness an actual discernible work against the United States. The Constitution also works to limit the punishment extended to those convicted of treason. As stated, there have been virtually no treason prosecutions in the recent history of the United States. Many believe that treason charges have become extremely uncommon due to the Supreme Court's previous rulings making such exponentially difficult to prove. But this idea is wrong. Granted, the Supreme Court did make treason prosecution more difficult, but it did not put the incurrence out of reach. A more understandable reasoning for the lack of treason prosecutions comes from the decisions made by the Supreme Court. This made it more accessible for the prosecutions of non-treason crimes, such as violations of various acts of Congress. This has been the scenario for multiple instances of criminal offenses that can be perceived as very similar to treason. Today, as a result of Supreme Court decisions, prosecutors can virtually always charge those with non-treasonous activities, therefore bypassing the protections of the Treason Clause, and Congress has passed multiple national security laws with the intent to further protect the United States. As the plethora of federal offenses has expanded, the reasoning for bringing treason charges has diminished. Since the disappearance of treason charges, one should still not completely discard the relevance and historical importance of the treason clause. Proving treason is not impossible, and it is still possible that treason charges could be brought more frequently. The principles underlying the treason clause are not specific to that clause and should be applied to national security issues generally. The founding fathers were right in differentiating between treasonous action and treasonous thought. The founding fathers also respected the idea that treason trials could inspire passionate public response and should therefore have more limitations. One instance of the Constitution using the word war can be found in Article 3, where it is in regard to levying war against the United States. It is easily read that the judicial branch of the United States would be responsible for protecting national security interests as it would any other judicial role. There have been dozens of moments where individuals and groups within the United States and abroad have given aid to enemies or otherwise attempted to hurt the nation. These instances are filled with such that individuals were charged and convicted of crimes other than that of treason. There is obviously a means to avoid the protections outlined in the treason clause. The Supreme Court has openly stated that they do not intend to charge those with what would be called treason, merely through the means of another named charge. However, this has not ordinarily been the scenario through which they have practiced. The lower courts have even been able to avoid the protections outlined in convicting one of treason by subverting with other named offenses. Some convictions do not even necessarily contain the requirement of material support for the enemy and can be as simple as translating language for the enemy. For example, the treason clause is programmed to protect important individual rights and should be used in determining whether treasonous acts have been committed against the United States, not other so-called crimes with other titles. Okay, let's fix this a little. All right, Article 4. Section 1. Full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. Article 4 of the Constitution is essential in establishing the states' relationships with each other. The full faith and credit clause describes how states must be coherent and respect all other states' institutional structures and laws. The beginning of the clause requiring each state to pay attention to the other states' statutes, public records, and court decisions. The second sentence of the clause allows congressional decision-making regarding how such documentation can be used in court and to what extent it will be effective. Currently, such materials should be respected the same in one state as they are in the state from where they originate. However, these records are not always given the exact same respect as they are afforded in the home state when examined by another, for example, licenses to carry or hunt. Another issue is that when states have differing laws, the Supreme Court has upheld that it is not possible to give effect to certain laws similarly across state lines. Sometimes if issues arise between two citizens of the same state but take place in another state, then neither state's laws can be applied. Once a court decision has taken effect, the judgment will decide the rights of the parties that were involved in the state where the issue took place, even if it might be against the state's laws. Recently, the most intense application of the full faith and credit clause has been seen in family courts where marriage laws differ between states. Article 4, Section 1 had two basic purposes: to identify public records and documents from the various states, and to allow Congress to designate those documents as legal. However, history has been forgotten and the courts have overstepped their bounds and diminished the powers of Congress. In the beginning of the United States, it was difficult to determine the legality of certain documents from the various states and county courts and their reputability. Therefore, full faith and credit was supposed to be given to such documents. But each state went about proving the adequacy of documents in different ways. Therefore, the Constitution, through Congress, provided a standard for moving documents across state lines to be used in court. Never, though, until the middle of the United States history did one state's laws have to be enforced in another state. Now, the Supreme Court treats documents coming across state lines as an almost mystical source of national unity. This suggests that the courts have taken over what was supposed to have been the responsibility of Congress, and who would be better suited to determine the legality of documents crossing state lines. The primary reason for the full faith and credit clause, as described by the Supreme Court, is to transform the several states from independent sovereignties into a single unified nation. When examining the clause, decisions should be made that promote national unity rather than state-related discrepancies. It has been established that judgments handed down by the courts in one state will be recognized in every other state. This is in line with the idea that the law hands down the final judgment is intended to guide the state courts. All the typical laws and statutes are different, and there are situations in which an implication may take place in one state but could possibly fall under the governance of another. And in this case, one state generally is not required to bow to the ideas of other states on matters of public policy. The idea that states are experiments for introducing and practicing new policies is still relevant, and the states are considered to be co-equal sovereigns. but the implications become more questionable regarding things such as marriage. If one were to get married in a state and then move to another where that marriage is not permissible, do the married couple still present with the same rights? This is the most convoluted aspect of the full faith and credit clause. In regard to marriage, it is mostly argued that it falls under the same judicial reverence as other state-level lawmaking, such as workers' compensation or insurance regulation. But this is questionable because it disregards the implementation of the personal rights that come from the institution of marriage. Further implications emerge because of the deep and lifelong status of marriage, of which the Supreme Court has stated is the foundation of the family and of society. Although same-sex marriage has been recognized universally among the states, other types of marriage, such as between first cousins, have been debated and not universally recognized, putting even same-sex marriage in a sort of jeopardy. Another area of trouble in family law in regard to the full faith and credit clause is related to state recognition of a child adopted in another state. One view accepts that a child adopted in one state shall be recognized as such by all other states. However, the alternative views, such as in the case where an unmarried couple adopts a child in one state but is prohibited from doing so in another, the receiving state does not have to accept the validity of the adoption. The Supreme Court has ruled that although judicial employees must honor the binding of states, administrative officials who are not judicial in nature do not. Article 4, Section 2 reads, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. A person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. The fourth article of the Constitution revolves around the relationship between the Union and the states. Section 2 outlines 3 clauses, all of which are relevant to the movement of people throughout the United States. The first clause is the Privileges and Immunities Clause, which grants privileges and immunities of citizens in other states. On the other hand, the second clause, the Extradition Clause, allows for the removal of citizens who have committed a crime in another state back to the state where the crime occurred. And the third clause, which is now obsolete, extends to slaves and allows for their extradition. Different from the other clauses present in Article 4, Section 2, does not prescribe the powers of enforcement or the duty to Congress. Alternatively, the phrases shall be entitled and shall be delivered up are used disregarding any examination of the authority under which they should be used. The clauses only mention the entitled persons to whom the benefits are given and the executive of the state where the crime occurred. Prior to the Civil War, both the Fugitive Slave Clause and the Privileges and Immunities Clause had several controversies surrounding them. These legal disputes reflected deep political divisions on questions related to slavery, race, and citizenship. However, in the period after the Civil War, Section 2 of Article 4 has widely lacked dispute, and modern jurists very much agree on the meanings central to the various clauses. The Privileges and Immunities Clause, this clause allows citizens of a state to enjoy equal treatment by citizens of another state when visiting such. In general, it prevents discriminating against a citizen based on that citizen's home state. There are limits to the Privileges and Immunities Clause, however, such as those relating to voting and office holding rights and particular licenses. The Privileges and Immunities Clause reconciles the independence of states and the union of the federal government. The clause actually originated in the Articles of Confederation and, with several changes, was incorporated into the Constitution without much debate. One important debate, however, during the founding revolved around the deportation of property brought into another state back to the state it originated from. This was mostly due to slavery and slave owners. Slavery and the Privileges and Immunities Clause would become essential to the debate surrounding the Civil War. Debates swirled around whether slaves considered by Southerners to be property were protected or not by the clause. Also, there was controversy as to whether free black people were allowed to carry over legal rights granted in free states to states that did not provide the same legal rights to people of color. Another issue even arose around the citizens who held anti-slavery opinions and whether they were allowed to travel amongst the southern slave states. Many argued that those with anti-slavery opinions held rights of interstate travel just as much, if not more, than those who would travel to free states to collect runaway slaves. The Extradition Clause. This clause is responsible for the return of convicted criminals in one state back to the state they originated from. It is a reflection of the Privileges and Immunities Clause and allows for the implementation of the enforcement of crimes committed in one state against the other states. There is not much difference between what was outlined in the Articles of Confederation and what is present in Article 4, Section 2 of the Constitution. Originally, the extradition clause required documentation to be filed legislatively in seeking the extradition of convicted fugitives. Shortly after the ratification of the Constitution, the Fugitive Slave Clause was added, making it the duty of the executive authority in action pursuant to extradition. Almost all issues surrounding the extradition clause relate to slavery. In modern day, nearly every state has adopted the Uniform Extradition Act, which allows and interprets extradition broadly so that it is not required that the convict have fled intentionally to avoid being prosecuted. The Fugitive Slave Clause. This is one of the 5 clauses that directly relate to slavery within the Constitution. It was not as controversial as it eventually became when it was adopted. The Fugitive Slave Clause would allow for the return of runaway slaves who had fled to freedom in other states that did not endorse slavery. Although in practicality, this clause did allow for the return of slavery and basically recognized it as an institution, the Constitution did not, in fact, recognize the legality of slavery. And therefore, fierce debate over the constitutionality of slavery would become persistent during the years after the adoption of the Constitution. Similar to other clauses concerning movements of persons throughout the United States, the Fugitive Slave Clause did not specify powers of enforcement. However, it did allow for slave owners to send others to procure their runaway slaves and return them with approval after bringing the slave to a nearby judge or magistrate. The procurement of runaway slaves was often based on oral argument, and loose legal binding proceedings were involved. There was a severe lack of protection for runaway slaves who were put on trial, and there was no time limit for incurring their retainment when running away. There was a period leading up to the Civil War in which many northern states tried to provide basic legal protections for runaway slaves, such as preventing the use of state resources to apprehend them, as well as trials by jury and the ability to testify. There was a conundrum between states in which slave state citizens had the ability to seek and return slaves, while the free states had the ability to prosecute such for kidnapping charges. There was a series of Supreme Court and federal court cases that would further the complications of returning runaway slaves and make for more complicated interpretations of the law. Eventually, federal officers became involved in the apprehension of fugitive slaves, and state officials would lack the ability to interfere. There was a movement by many people in the northern states that did interfere with the kidnappings, however, in extravagant and outstanding ways. The basic premise of constitutional interpretation and whether it allowed for the institution of slavery became under question by many. Pro-slavery advocates argued that slavery was essential and integral part of the Constitution, while abolitionists argued otherwise. A lot of this revolved around the idea that one was able to travel amongst the states with what they considered to be their property. One prominent abolitionist argued against an originalist interpretation of the Constitution in which the written Constitution did not concern slavery in any sense, regardless of what the Founding Fathers' intentions were. He also argued that the semblance between the Declaration of Independence and the Constitution, in which both documents should be read in conjunction and in compliance. Some of the more moderate anti-slavery citizens would argue that although the Constitution did cede some rights to slave owners and their abilities, such ideas were not foundational to the Constitution and did not warrant principal recognition. Mostly the Reconstruction Amendments following the Civil War did resolve the complications surrounding Article 4 of the Constitution. They abolished slavery throughout the United States and completely obliterated any right to own another person. The amendments also began a pattern of disregarding persons based on the basis of race. In summary, Article 4's Fugitive Slave Clause did much to upset the nation and eventually helped lead to a civil war. There was much controversy and debate, so much so that it led to bloodshed and the rupture of a nation. Article 4, Section 3. New states may be admitted to the Congress, may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state, nor any state be formed by the junction of 2 or more states or parts of states without the consent of the legislatures of the states concerned as well as of the Congress. The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. The Admissions Clause allows Congress the ability to admit new states, primarily the conversation at the Constitutional Convention surrounded the ending portion of the clause, which allowed that new states may be created from parts of existing states with the permission of that state. Many small states feared that the larger states would never diminish their own territory in creating new states. However, the majority opinion was that politics would disallow division of territory against the state's will anyway. Although the consent requirement was the most controversial part of the clause at the founding, it has only come to be debated in a few scenarios throughout the United States history. Far more important is the beginning of the clause, which allows the general formation and admittance of new states. 37 states have been admitted as a result of this power given to Congress. There is no clear guidance present in the Constitution as to how Congress is to expend this power, nor is there much contextual argument regarding scope found in the framing. Therefore, much regarding this clause is the result of case law and historical context. Most of the new states have been admitted only after being governed as new territories, which was pursuant to the Property Clause, and which may also be found in Article 4, Section 3. A congressional act was typically made to establish a territorial government, which led to a more self-governing and eventually led to adoption into the Union. The Admissions Clause prescribes that Congress must enact an act in order to admit a state, but there often came a more convoluted process. The Enabling Act was passed by Congress, which allowed for a territory's population to come together in constitutional conventions, drafting such in order for proposal and application of becoming a new state. Particularly, in many instances, Congress outlined conditions for these constitutions and their admission into the Union. Some examples were the disallowing of polygamy or slavery and enforcing religious tolerance. One possibility was even to give final approval to the president after a review of a state constitution being submitted. The most extensive controversy the courts have seen in regard to the admissions clause is the swath of power given to Congress to instill such conditions and therefore limit sovereignty. There is no equal footing clause in the Constitution for the admission of new states, but the Supreme Court has practically read the clause as such and admitted into the Union on an equal footing with the original states in all respects whatsoever can be found in almost every state's admissions act. The equal footing doctrine, as prescribed by the Supreme Court, was enacted throughout the United States history and even goes so far as to prevent Congress from legislating on where a state capital was to be established. The doctrine also does not regard economic, geographic, or ecological conditions that may give some states more resources than other states, and only respects the autonomy of states. The federal government is not responsible for giving up land that it owns in newly created states. The most extreme part of the admissions clause, as it relates to constitutional law, is the Supreme Court's implementation of the equal footing doctrine. The doctrine was created by the court, but following such, the doctrine has come under much controversy outside of the judiciary. The court has described the equal footing doctrine as not preventing Congress from creating conditions on new state admissions, as long as Congress retains the ability to impose such conditions in other legislation that is in line with the Constitution. Therefore, courts have continued to maintain the legality of enabling acts in which public land given by the federal government statute or other means is dedicated for purposes through Congress pursuant to the Property Clause. The Property Clause allows for Congress to legislate on federal government land throughout the United States. Also, the lower court system has continuously described the doctrine as not requiring states to be equal other than through their main points of sovereignty. Hence, many states are disproportionate in having a certain percentage of land dedicated to the federal government. This causes many politicians and elected officials to be dismayed and argue severely that the equal footing doctrine should maintain that the federal government is to forego the owning of land in specifically Western states, where a lot of land belongs to the federal government. All of these arguments have been rebutted by the federal court system, and the Supreme Court has gone so far as to explain that the giving up of federal land in newly created states has not become practice due to severe precedent. The point to be seen is that the importance of the admissions clause is seen through practice and not just in the constitutional legal principles developed by courts. Regardless of the equal footing doctrine and its description by the Supreme Court, however, newly admitted states have been conditional on their acceptance of requirements by Congress. Some of these states have had conditions that were set upon their political systems, such as requiring jury trials and other instances relating to criminal offenses. Public officials have even been made to speak English in school institutions and related practices. These conditions were imposed by Congress with the intention of being in line with the United States political value system. Assimilation into the Union was the utmost importance in many instances of Congress's constraints on newly admitted states. The limitations of the equal footing doctrine can be seen in the uneven percentage of federal lands and rather uneven implementation of constraints on political systems in newly admitted states. The point to be made here is that the admissions clause is of equal importance with the case law relating to the equal footing doctrine itself. An important implication of the equal footing doctrine is how it relates to current members of the Union and their equality in relation to sovereignty. The court has used the equal footing doctrine to determine and argue that states must provide equal status amongst them when it comes to sovereignty. There are 4 parts of legislation that distinguish between voting practices of various states and were different between them have been struck down in the past. The Supreme Court in one instance stated, there is a fundamental principle of equal sovereignty among the states. The purpose of the admissions clause is to give Congress the ability to admit newly created states in a co-equal manner and into a co-equal union. The equal footing doctrine portion of the admissions clause is instilled in the commonality of the Union and has been described as a federal compact. The Supreme Court has argued that the nature of this federal compact is derived from the language present in the Constitution. The purpose of co-equal sovereigns is to maintain the way that the Republic of the United States operates and is organized. The union of the Constitution is not the same when there is uneven power distribution amongst the various states. Therefore, the Admissions Clause and the Equal Footing Doctrine are permissible only through the lens of a much broader idea that states are equally sovereign in the Union itself. Constitutional power granted must be equally represented in all of the states. Congress is not able to exercise its powers in a way that disrupts the equality of the states. This can be traced back to the founding, where it was abundantly obvious that the states were to be held equally powerful. The argument amongst the founding fathers never revolved around equal sovereignty, though. Instead, it was related to equal representation. It is instilled in the founding, however, that the Federation is consistent upon a group of co-equal sovereignties. Article 4, Section 4. The United States shall guarantee to every state in the Union a republican form of government, and shall protect each of them against invasion, in non-application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. The Guarantee Clause maintains that the United States must guarantee to the states a republican form of government and provide protection from foreign invasion and domestic violence. The Guarantee Clause is not often referred to by government entities, but there is much agreement on its meaning. The Guarantee Clause instills a majority rule and therefore a republican government in which the government is chosen by election. The Guarantee Clause limits the choice of government that a state might strive for. There's no allowance for any other form of government that bypasses the requirement of the electoral process as required by the Constitution. There are variances present in the republican form of government required by the states. However, voter qualifications, for instance, were left to implementation by the states, although altered significantly later through amendments. The Supreme Court has upheld various forms of direct democracy practice, such as popular referendums, and has shown the willingness of the courts to allow varied forms of republicanism. Federal legislation affecting states and given by the Constitution does not typically violate the Guarantee Clause, even if such legislation prevents specific state dealings. Because of the Supremacy Clause, though, federal legislation will at times override valid state legislation. The question of whether the Guarantee Clause is considered judicially enforceable by the federal court system is convoluted. Initially, the Supreme Court held that any issue with the Guarantee Clause would have to be resolved by the President or Congress, and it has even been declared that a republican form of government cannot be reinterpreted by the courts. However, recently, the Supreme Court has decided that the Guarantee Clause should be inspected on a case-to-case basis, though protections against domestic violence are typically limited to extending from the President or Congress, and therefore the structure of this section is obliged primarily to those branches of the government. In regard to African American voting rights, there is a substantial argument to be made that the Guarantee Clause was not respected by the United States government. After the Reconstruction Amendments, the Supreme Court maintained that African Americans were protected by the clause. The populations of African Americans were extremely substantial in many southern states, and sometimes even majoritarian. However, they did not see their representation and influence that they were owed. Instead, African Americans were systematically disenfranchised, specifically in the states where they held a majority of the population. Mississippi, for example, decided that African Americans were simply not educated enough and unfit to hold positions of responsibility and decision-making. That state even recognized and declared itself to be under minority rule. The United States then failed to guarantee a republican form of government and did so in many other formerly Confederate states during and after Reconstruction. Several legislative acts even followed that recognized the disenfranchisement of African Americans and its correlation with minority rule. The United States does not have the ability to substantiate alternative voting structures in the states, but does have the responsibility to maintain the principle of majority rule. Again, with regard to the Guarantee Clause, there is not much that can be done by the states to define such a franchise. States are able to construct requirements for electing on the state and local level. However, this gives rise to the Guarantee Clause not being able to provide federal power to operate and monitor local and state elections. There have been several amendments enacted that narrowed the governance of voting rights restrictions, in turn substantiating the Guarantee Clause. The Guarantee Clause limits the type of government a state may adopt and instill, but also allows for autonomous operation of government in regard to popular vote. The federal government may therefore not intervene with state functioning per se, but may alter such through constitutional amendment procedures. Okay, Article 5. The Congress, whenever 2/3 of both houses shall deem it necessary, shall propose amendments to the Constitution or on the application of the legislatures of 2/3 of the several states shall call a convention for proposing amendments, which in either case shall be valid to all intents and purposes as part of this Constitution when ratified by the legislatures of 3/4 of the several states or by conventions in 3/4 thereof, as the one or the other mode of ratification may be proposed by the Congress, provided that no amendment, which may be made prior to the year 1808, shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state, without its consent, shall be deprived of its equal suffrage in the Senate. Catch my breath. Okay, Article 5 of the Constitution outlines the procedure for amending said document. There have been 27 amendments, and the process for doing so is arduous. There are several different ways that the Constitution may be amended. The first method, which is the one and the only one that has ever been used, declares that the states must decide on the ratification of an amendment after it is proposed by Congress. 2/3 of both chambers of Congress must vote. 2/3 of both chambers of Congress must vote for the amendment's proposal, and then 3/4 of the states must ratify it. In this instance, therefore, it only takes a small minority of the United States to prevent an amendment from being ratified. There is an alternative way for an amendment to become ratified in which the states can circumvent Congress. This is the procedure by which the Constitutional Convention for proposing amendments is called forth, and it requires 2/3 of the legislatures of the various states to submit an application to Congress. In this scenario, the proposed amendment following the convention would be sent back to the states and require 3/4 approval for ratification. Article 5 similarly allows for Congress to differentiate between two separate ways for states to ratify an amendment. It can be done through those state legislatures, or Congress can call for the states to have conventions with the intention of considering ratification of the amendments. Amendments to the Constitution have been seen to come in groups. The initial 12 amendments, which include the Bill of Rights, the first 10 were all incorporated into the Constitution by 1804. The next group of amendments came following the Civil War, in which amendments 13 through 15 were ratified. Then 16 through 19 were added in the second decade of the 1900s, and from 1920 to 1971, 6 more amendments were added at approximately regular intervals. This is an outlier amendment, the 27th. There is an outlier amendment, the 27th, which was proposed with the Bill of Rights and ratified by many states, but did not become incorporated into the Constitution until 1992, over 200 years from its introduction. It can be seen there is no limit to ratifying an amendment from when it is introduced. However, there may be a time limit if it is specified by Congress, as is the case when modern amendments are proposed. There are some paradoxes when it comes to the ratification of amendments, such as the rescinding of a state's intentions to ratify after proceeding to do so. Also, there are some parts of the Constitution that cannot be changed or amended, one being that the equal voting institution of the Senate cannot be prohibited from a state unless a state wants less Senate representation. The second was the depreciation of the Constitution, which stated in convoluted language that the slave trade could not be limited until 1808. Article 5 has 2 important instances to note. Firstly, the Constitution is very difficult to amend. Secondly, amendments are not as important as the public believes. Although amendments change the written text of the Constitution, the more substantial changes happen while the text remains unchanged. The Constitution undertakes change regardless of whether an amendment is made. As a result of the Constitution being so difficult to amend, the United States has become well versed at circumventing such processes. Congress, the President, and the court system, as well as the public definition of text, have all come together to change the meaning of the Constitution while the written language stays the same. Some argue that the interpretation of the Constitution has changed, but regardless of how it is explained, the understanding of the essential document has evolved over time. There are 4 facts that revolve around the Constitution. First, there have been substantial differences in the structure of government other than what is outlined in the Constitution. Second, many amendments were added after the change had already taken place. Third, sometimes an amendment is proposed, then rejected, and the change takes place regardless. And fourthly, some ratified amendments intended to change operations did not do so as they were initially intended, but did so at a later period. Some examples of these include the transference of power from the state government to the federal government, the change of Senate elections from state legislatures to popular vote, the Equal Rights Amendment not being ratified but enacted through court interpretations of law, and the suffrage of African Americans, which was incorporated through amendment but did not become standard practice until later. Amendments are simply a small method for changing the way the Constitution delineates and operates, and the majority of change comes from judicial interpretation, congressional statute, presidential decree, and public opinion. The idea that the United States should incorporate the original meaning of the Constitution into governing is known as originalism. As mentioned, an originalist point of view would maintain that the outline amendment procedures are the primary way to change the Constitution. However, it has been stated that there are two problems that arise in the amendment process. The first is that it is too arduous and troublesome to impose amendments. The second is that the amendment process heavily favors the federal government and lacks the ability to limit it. It can be seen, though, that these issues stem from a lack of originalist interpretation. If originalism were to prevail, these two problems would cease to exist. Many critics of originalist views have decided that the amendment process is too strict, since it is very difficult to obtain approval of 2/3 of both chambers of Congress and 3/4 of state legislatures. These arguments would agree that the Supreme Court should maintain non-originalist judicial interpretation, therefore allowing change into the Constitution based on modern values and beliefs. Regardless, the amendment procedures are not too strict. There are very important reasons for disadvantaging popular change to the Constitution. For example, subjugating a substantial minority to constitutional change that might diminish the dedication to the Constitution itself. Furthermore, the amendment process has allowed for extremely substantial change over its history with the enactment of the Bill of Rights and other amendments. The issue at hand is that the Supreme Court is too hasty in attempting to alter the Constitution, and before an official consensus has been made to amend the Constitution, alterations have been made prematurely. This view helps to explain why there has been substantial constitutional change recently with a lack of amendments being ratified. It can be argued that instead of packing the Supreme Court with sympathetic members, a consensus would naturally take place to alter the Constitution without the need for subjective judicial interpretation. The second issue of the amendment system regarding the natural favoring of the federal government can be seen through the way amendments have been produced as a congressional vote rather than calling for a convention amongst the states. Excuse me. The founders understood that the method through which amendments are made by congressional vote is controlled by the federal government and therefore favors it. The founding fathers must have introduced the alternative in which a constitutional convention is called in order to circumvent federal government reliance and oversight. Okay, so there is a bleak dissuasion against the calling forth of a constitutional convention because of the possibility of it becoming a runaway convention. In this case, the purpose of the convention changes and the original issues are not addressed. This is unfortunate because many diminishments of the federal government that would be beneficial, such as line item vetoes, are not possible. Many will argue that the problem of runaway conventions is perfectly constitutional and a substantiated issue with calling forth a convention. However, the purpose outlined in the Constitution for calling a convention is for the proposing of amendments solely, and morphing the subject would be unconstitutional. A limited convention can be called forth, and if an originalist interpretation were adopted more robustly, the arrangements for the diminishing of federal overreach could come to fruition. The primary understanding to be held in this argument is that if a limited convention, as exemplified in originalist thinking, were held, the problems in the amendment process would not persist. Okay. I don't know if I'm going to finish in time. Article 6, all debts contracted and engagements entered into before the adoption of the Constitution shall be as valid against the United States under this Constitution as under the Confederation. This Constitution and the laws of the United States shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state, to the contrary notwithstanding, the senators and representatives before mentioned and the members of the several state legislatures, and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Article 7, the ratification of the Convention of the United States shall be sufficient for the establishment of this Constitution between the states so ratifying the same. The word "the" being interlined between the 7th and 8th lines of the first page, the word 30 being partly written on the erasure in the 15th line of the first page, the word is tried being underlined between the 32nd and 3rd line of the first page, and the word "the" being underlined between the 43rd and 4th lines of the second page. During convention by the unanimous consent of the states president on the 7th day of the suit. Okay, so anyway, Article 7 experience. I'm confused with what's going on there, but okay, Article 7 experienced its general effect during the time of the founding of the Constitution and has not had any interpretational controversy ever since. Article 7 declares that the Constitution shall become the binding law of the land as a result of the ratification by 9 states. The Constitution saw its 9th state ratified in 1988. I have it tattooed on my thigh. Besides not being controversial, there is still much to explain regarding Article 7. Controversies that existed during the process of ratifying the Constitution were in regard to the process itself and not over the text that was written. The principal argument that existed between Federalists and Anti-Federalists was over the legality of the ratification process. This is because the Articles of Confederation and Constitution were inconsistent. The Articles of Confederation would have required an agreement by the United States Congress and then confirmation by all state legislatures. The Constitutional Convention required only ratification of 9 states and 4 went congressional approval, as well as substituted conventions for state legislatures. Therefore, many anti-federalists argued that the Constitution ratification process was illegal. Federalists argued otherwise, stating that the Articles of Confederation were an invalid treaty to be disposed of as a result of violations taking place repeatedly. Some also argued that a sovereign group of people were obliged to abandon an unsuccessful constitution. The founding decisions to change from ratification by state legislatures to conventions were influenced by general and important concerns. The ratification of the Constitution was argued to be implemented by the people rather than the legislative entities of the states. Although a modern approach would have been to hold a popular referendum, the resulting convention elected by the people was an option appropriate for the time. The conventions, therefore, employed a representative democracy rather than a direct one. Also, it was important because many aspects of the Constitution would diminish the powers that current state legislatures had enjoyed. It can also be seen that it was essential to bypass the ultimatum requirements set forth in the Articles of Confederation. It was nearly impossible to change the Articles of Confederation because things had to be done through unanimity amongst the states. 9 out of 13 states allowed for consensus without a minority being able to block ratification. The conventions being held at the state level and the people themselves allowed for the Constitution to be ratified by popular opinion of the public rather than an agreement between state governments. During the Civil War period, the Confederate States chose to alter the status quo and viewed the Constitution as a compact between state governments. They would typically hold a convention to rescind the ratification of the Constitution, viewing that ratification as a decision by the state. Although only 9 states were required for ratification of the Constitution, the Founding Fathers anticipated agreement amongst all 13. The political division revolving around Article 7 exposes the importance of how constitutions are intended to be implemented, besides what is said in or meant by the text. If literally understood, Article 7 promised a constitution that would be detrimental to the United States. If some states were left out, scenarios existed amongst the founders that included partial confederacies having frequent and violent contests with each other. Regardless of the literal interpretation of Article 7, the principles of the Constitution were implemented for all 13 states that existed. The use of the United States of America carried over from the Articles of Confederation and showed the intentions of all 13 states being in agreement and a congruent entity. A question arises of how to treat the remaining states after 9 had approved ratification, whether the remaining were under the jurisdiction of the United States or whether they were separate entities was up for debate. The Constitution did not express how to deal with this scenario. The Founding Fathers did not spend time arguing about such a case because they did not believe it practical or even possible for a lack of 13 states to be as one nation. It was determined that if not all states agreed on ratification, it would be absolutely disastrous for the Constitution in the United States of America. There are 2 ways that the requirement of ratification by 9 states would encourage whole ratification by the nation. Early ratifiers would be allowed early access to the Constitution and therefore the ability to make critical changes and decisions, and late ratifiers would be exempt from arguing for better conditions. The ratification process had a momentum effect in which each added ratification would heavily increase the likelihood of unanimous ratification. Many state conventions ratified under the pretext that doing so later would be devastating, as wholly ratifying the Constitution was deemed inevitable. It was understood by those initially opposed to the Constitution that joining in an effort to effect mending it was more responsible than opposing it outright. It is important to note that the state conventions voted for ratification of the Constitution in its entirety, and as momentum increased, it was detrimental to not vote in favor immediately. As time has passed, the importance of Article 7 has unfortunately been largely forgotten. Article 7 outlined the procedural process for the Constitution to become an enacted law. The Constitutional Convention simply created a proposal that would only be enacted once a conditional ratification of 9 out of 13 states took place. The Constitution stated that those states that chose not to ratify were not bound by it and therefore would become independent. This can be considered the legal force clause. It can be argued that constitutions that require supermajority for ratification and amending are usually desirable. One positive aspect of a supermajority requirement is that they permit a consensus and support for a proposed constitution. Unless a large majority supports the Constitution, it is likely not to succeed in being ratified. The Constitution has a sense of commitment and unity because it is supported by a supermajority. Another positive aspect of a supermajority requirement is that it permits better making of decisions since a supermajority is required for amending and ratifying the Constitution. It is likely that protections will be put in place to protect minority groups and opinions. The predicting of implications and outcomes is difficult, therefore it is common sense to provide for minority protections in case of discord. The enacting of the Constitution requiring a supermajority likely increased pressure to substantiate and enlarge the federal government because that would be the only way it could garner enough support. It would have been easier with a simple majority to entice only the larger states to ratify the Constitution, but in order to garner support from smaller states, the federal government had to be enlarged. The same case can be applied to the Bill of Rights, which, in order to gain a larger support base for the Constitution, it was promised that such a bill would be introduced after the creation of the government. The idea that state conventions were based on a simple majority does not make the ratification of the Constitution majoritarian. Similarly, senators and representatives must fit in supermajorities, but both are elected by majoritarian practices. This does not make Congress based on a simple majority. And we're done. So that's my book so far. It's about 20 to 30% done. It needs a lot of editing, especially that third grade part on the Constitution. The first part, again, is pretty much off the dome. And the second part is going to be mostly about these books here and my political notebooks. John Locke. That's who I forgot influences me. And that's all I have. Thank you.